Welcome everyone. I'm pleased to have here in this Privacy Espresso episode, Kelly Dickson, Managing Principal Lawyer of the Dandenong office of Macpherson Kelley in Australia. Evidently, we have been hearing a lot of data privacy updates and news from Australia, so we want to have Kelly here describe them. Kelly, welcome.
Hello, thank you very much, and hello to everyone who is watching and listening to this. It is actually a good opportunity for us to be speaking about some Australian developments in privacy law. I do know that all around the world there's been various media grabs and newspaper articles about some of the things that have been occurring here in Australia. So I thought what we would do today is talk just very quickly about some legislative developments that are occurring in Australia and also look at some interesting recent cases as well to know about these new privacy proposals that are in Australia because they will have some big impacts.
Perfect, Kelly. So can you tell us why normal businesses or otherwise all businesses should be aware of these privacy law consultations?
Yeah, so in Australia at the moment, there are two privacy consultations that are before Parliament and being looked at by some of our committees. And what I think is really important to note is that both of these consultations have been framed and they have been named as online or digital consultations and pieces of legislation. So I think it's very easy for businesses to say, oh, well, I don't need to worry about this because it relates to online platforms or it relates to digital platforms. But the actual legislation goes a lot more deep and broad than that. So it can apply, if this legislation is passed, to all sorts of businesses. So for the first one, which is a proposed online privacy bill, what it's going to do is create a code for social media platforms, but for all businesses, what's also hidden in there is that there is a proposal to increase privacy penalties in Australia to match the penalties in our consumer law. So that means that the penalties can be the higher of $10 million, 3 times the benefit received from the contravention, or 10% of turnover. And our Privacy Commissioner is also proposed to have some new investigative powers. Then the second proposal, if it gets passed, will bring Australia's privacy law a little bit closer to GDPR. Some of the proposals that are in this piece of legislation are for there to be a direct right of action for individuals to take against businesses, some changes to definitions to improve the understanding of privacy, but also importantly for Australia, we're looking at more prescriptive notice and consent requirements, introducing some standard contractual clauses, some SCCs that we've never had before, some changes to default settings for privacy as well, and a right to object and to erasure, which are rights, in GDPR jurisdictions, but not here yet for us. So I'd encourage people to continue to look at this as it passes through consideration, but don't discount it just because it relates to digital.
Thank you very much, Kelly. Evidently, so Australia is one of those countries that has initiated a pattern towards the GDPR international standards, also in terms of fines. Let's talk about the case. Around the world, the news went that the New South Wales government suffered a data breach. What can you tell us about it?
Yeah, so this was an interesting one. In New South Wales, which is one of the states in Australia, there was a data breach. There was a leak of 500,000 addresses. And this was related to COVID and our QR check-ins and those sorts of things. What made this interesting and concerning for people is that those 500,000 or so addresses included defence sites, domestic violence shelters, Australia's infrastructure networks. And so, this was data that had been uploaded onto a website, probably in hindsight in situations when it shouldn't have been. Now, the New South Wales government did report that to the Privacy Commissioner, who determined that it was not a privacy breach as defined. And the reason for that is that the data that was leaked was business addresses. What the consequence is, though, is that some of those sites are very sensitive sites And so the thought in the public was, well, people could use that information to then go and visit the domestic violence shelters or the defence structures and sites. So it wasn't a strict privacy breach, but it certainly caused some concern for Australians and for more vulnerable consumers. But I think that what it also did was, it's quite timely at the moment, we're currently looking at our QR check-in process and whether now that Australia is starting to open up from isolation again, just how useful and effective doing a QR check-in is. So, I think it's just brought to light that there is an awful lot of data, and particularly through COVID, so much data was given to government, shared with government, and this breach really was perhaps just not some great thought about what was being made available in circumstances where it didn't need to be, really.
Very interesting. And there are some other interesting cases. For instance, the 7-Eleven you mentioned briefly in the outset.
Yeah, so 7-Eleven is a case that has happened just recently in Australia as well. And this is where our Privacy Commissioner has made a determination that 7-Eleven, the convenience store, did interfere with customer privacy. So what 7-Eleven was doing in Australia in some of its stores was it had put some iPads, some tablets in store to record customers' in-store experience. So people could do a survey once they were in store about how their shopping experience had been. But part of that was that these tablets collected biometric information. They took photographs of the people who were filling in the surveys. And 7-Eleven say that the reason that they were doing that was to help prevent duplicated surveys or people, circumventing that. But what the commissioner found was that that biometric information was also being used for demographic profiling, and there was no consent to that occurring, and that wasn't disclosed in the collection statements that were provided when people first signed up to one of these surveys. So that was held to be a breach of a couple of Australia's privacy principles, the APPs and the guidance that we have there. And it was basically about not adequate notice of collection and collection not being reasonably necessary for the primary purpose that they were doing all of this. So I think that, what that case was really about, and the reminder to Australian businesses, is about what are you collecting? What personal information is it? And why are you collecting it? And having that thought about, is the impact on privacy proportionate to what you're trying to do? So that was one of our commissioner determinations.
The fact that you echo this advice is particularly fundamental. So talking in terms of general policy, the recent data breach report of the Australian Information Commissioner was released. Can you give us your comment about it and some tips to businesses out there?
Yeah, so the OAIC publishes statistics about the number of data breach reports that we have. And Australia's data breach mechanism has been in place for 4 years now. So I think that the biggest tip and the biggest message to come out of the report is that the Privacy Commissioner isn't so much doing education as enforcement and expecting businesses to have data breach mechanisms in place. It's been 4 years, so businesses should now have appropriate systems in place. And maybe this is the case everywhere around the world, but the vast majority of data breaches come from malicious hacks and from human error. So really the message for businesses is to consider privacy and to have privacy policies in place and to have procedures for staff to follow and to train staff about what to do if something goes wrong or if they become aware that there has been a potential incident or breach. One of the saving graces perhaps in Australia is that our data breach mechanism reporting period is up to 30 days, not 72 hours. So Australian businesses do have longer to investigate and to try to work out what has happened. But that 30 days is certainly considered to be an upper limit and it should be notified a lot earlier than that.
Kelly, thank you so much. The clear message is 4 years were given. Now it's time to take action. And let's meet again with privacy rules in one of the next episodes. Thank you very much, Kelly.
It sounds good. Thank you.